Good morning, everyone. We're just waiting for a few folks to come in from the waiting room, and then we'll get started. Looks like that's slowed a bit, so I'll just get the preliminary conversation remarks out of the way. I'm Lisa McMahon. I'm here with Ken Hare to talk to you today. Just a few housekeeping notes. As always, please try to stay muted. It is helpful for us if your microphone is muted. If you have questions, go ahead and throw them into the chat, and we will try to get to them at the end of the Q&A, time permitting. We do have a lot of questions today, so that may or may not be possible. Reminder that all of our discussions today are general information. It is not legal advice. If you need legal advice, please talk to your attorney. Please make sure that anything you put into the chat is just our questions or requests for clarification, not legal discussion or commentary like on the CAI message board. And remember that anything in there isn't legal advice either. Reminder that the Corporate Transparency Act is sort of in flux at the moment. It has been challenged. It is being challenged by the National CAI, and we have recommended and are recommending that folks wait to comply until at least later this year, until things hopefully settle down a bit and we get some clarification. Reminder that the WSCAI Annual Conference is coming up not this weekend, but next weekend, April 19th. We have, I think, 3 CLG attorneys speaking, including me. So we hope to see you there. And that is at the Sheraton Grand Seattle. As I mentioned, we have a lot of questions today. Some of them have lots of parts in them, and some people submitted lots of questions. So we're going to try a new thing where we're going to be limiting the number of submissions to 3 per person. If you send in more than 3, we'll put them at the bottom of the list, and we may end up getting to them in future weeks. If you want to space out your questions to make sure they're answered, you're more than welcome to do that. And a final reminder is that a lot of the questions this week were very specific. Please remember that this Q&A is really intended to be broadly applicable to all the folks who are attending. So if you've got really specific questions, make sure that you talk to your association counsel about them. We can't answer those questions, and hopefully we'll let most of those people know. Our goal is to just respond to questions that are applicable to most of the people on the call. Ken, anything else to add? If not, I'll go ahead.
No, go ahead.
Okay. The first question is, I understand you may have answered this in the past, but it is still debate in our community. Does condo law have a recommendation regarding multiple family members serving on the board at the same time? For reference, we have 10 trustees on our board. A member and a spouse serving at the same time would be 20% of the vote, or more of that, depending on quorum. Can you share your thoughts and what advice you would give your client communities? The short answer to this question is that we recommend no more than 1 person per unit serve on the board. Your governing documents may have more information there. They may explicitly assign 1 vote, 1 unit, or something along those lines. Your bylaws may also have specifics on who can be a board member. And so I would start there. And if you have questions about that, ask your association counsel. But generally speaking, we would recommend that 1 person from each household be on the board, not married couple or partners. Anything to add to that, Ken?
Just, we have had some clients with very small communities that were happy to elect both a husband and wife or 2 people from the board. It's not illegal. It may be against the document you have, but it is still our recommendation that you get only 1 person from each unit. So next question, is there an obligation to distribute monthly financial reports to all proprietors? So I'm going to start by saying I don't understand the term proprietor in the context of community association. So I'm going to assume they mean owners of units. And the short answer is that you are not required to distribute monthly financials, but you're required to make them available to owners who request them. And so we've had a number of conversations about record requests. The statutes were all rewritten in 2023 to specify what records must be maintained and how they must be made available to owners, and when you can bill an owner for expenses related to getting records. So you can certainly look at that. If you were to type into Google, your statute, like RCW 64.38, and then the word records, the section that has this long laundry list and all the conditions adopted by the legislature will pop up, should be the first or second thing on the screen. Anything to add, Lisa?
I don't think so. I just want to point, you did mention that they need to be made available to everyone, just not sent out.
Yes.
Okay, next question. If an investor acquires a majority of residences within a community, does this grant them authority to make decisions on behalf of the community, given their majority voting power? The short answer to this question is yes. If the decision, every unit has a vote, as we talked about in that first question, but differently stated, but every unit has a vote. So if a person owns 2 units, they have 2 votes. You may have a different result if the decision needs a majority of unit owners. For example, you're doing an amendment, something like that. So the question really depends on what you're asking. What kind of vote are you talking about? But essentially, yes, if you own 2 units, you have 2 votes. And if you have 3 units or 4 units, same answer. But if you're talking about different kinds of voting options, amendments, etc., you may have a different answer. So that's definitely a question you'll want to talk to your association counsel about. Anything I missed there, Ken? I jumped around a bit.
Well, it occurred to me while you were talking that it may make a difference on whether or not they are on the board, because just having majority of the votes would only mean they would have the control of decisions made like at an association meeting.
Right.
If they have not elected themselves to be on the board of directors would still be who makes the decisions.
And they would still only get their 1 board position if they were voted onto the board. They don't get all their unit positions, for example.
Well, except that they may, because they have multiple units, they could probably
That's true.
have multiple board members.
That's true.
So, next question is, can the board convene to discuss routine business matters in executive session? So this just seems like a question we've answered multiple times about how the board can meet in secret without having an open meeting. And the answer is they should not meet in secret without having an open meeting. If they are under WUCIOA or they're a Homeowner Association Act entity, they're required to have open meetings. And the answer is no, you cannot discuss routine business in an executive session. If you're a condominium and your documents do not require that you have open meetings, then you can hold closed meetings and discuss whatever you want. We still would encourage you to have open meetings because it reduces the number of conspiracy theorists and the information that supports their belief that the board is doing bad things behind their back. Okay. So in terms of doing an executive session, which is a closed session, you're supposed to have a motion before you do it, stating the topic for discussion, and those are the only topics that you would discuss. And any decisions that are made are supposed to be done back in open session following the discussion. And there's a limit on the items you can discuss. So if you wanted to have an executive session to discuss the budget, I don't think that's provided for in the statute. Anything you want to add, Lisa?
I just want to clarify that the executive session is not a separate meeting held at a separate time. It is part of the regular board meeting. So as Ken said, you would have your board meeting, you'd make a motion, you'd go into executive session, and then you'd come back out and vote on what you had discussed, if appropriate, in that executive session. But the conversation may be private or off book, I guess, is sort of what it is.
That's correct.
Okay. Next question. In a prior recent podcast, Ken indicated that a meeting could not be called an executive meeting versus an executive session. What RCWs apply? So this question relates to the prior question. The RCWs that apply would be the open meeting provisions of WUCIOA or the HOA Act, if those are relevant to your association. I think the question is basically saying that, I think, talking about the name of the meeting. So you can't change the name of a meeting of board members to avoid the open meeting requirement for your association. So if whether it's called an executive meeting or executive session, I think what the person's driving at is it's the same thing. So if it's an executive session of the board meeting, we just talked about that in the prior conversation. And again, you wouldn't have an executive meeting at a separate, or executive session, excuse me, at a separate time. It is part of the board meeting that is happening. Anything you want to add to that, Ken?
Well, I think the legislative intent is to basically go against what a lot of boards find incredibly efficient, which is the use of email to have discussions and make decisions. The legislative intent is that the discussion between the board members is open and available for memberships to to observe and listen to. And I don't think that boards want to start making all of their emails available to all the owners. And we recognize that the open meeting requirement is an inconvenience and an irritation, but that doesn't mean that you shouldn't follow it. Next question. At what point is an individual deemed delinquent in their dues? Is there a defined threshold? If an owner is inadvertently behind $2 or $15 over several months due to payment errors, should the HOA impose late fees and issue delinquency notices? And should they include that in a first notice of foreclosure? Okay. So this is going to be way too specific for us to give any, kind of real legal advice. My primary comment is that any fines should be reasonable under the circumstances that have occurred, as they might be viewed by a court after the fact. And if you're imposing fines for a $2 or $15 delinquency that's months old because of a payment error, I don't think a court's going to look very kindly on that. And sometimes the governing documents will state very clearly that if a payment is not made by its due date, it is delinquent. But most of our clients have collections policies where they will provide a grace period of anywhere from 5 to 15 days, that as long as the payments come and cleared by that date, then no late fee will be assessed. So you kind of have to look at both the governing documents and then any kind of collections policy that you've used. And then you have to look at, is it reasonable? If a person's paying regularly, but the check's not coming in till the second or third day of the month, then it's probably not reasonable to be assessing them late fees and interest. Okay? But if a person is habitually 20 or 30 days late, maybe it is worth taking some action. But remember, it has to be viewed after the fact by a court. And that's the lens we use in trying to decide whether we want to pursue collections in court. Anything to add, Lisa? You do this more than I do.
No, I was just going to say, I wondered if the question was more if someone's assessments per month are $252 and the person's paying $250 every month. And so there's a $2 balance every month. I think the answer is still the same. I would personally probably want to reject a file that came to me that had a whole bunch of $2 a month charges on it. I would hope that you'd be able to work with the owner outside of the collections process to get them more on track to making those payments. But as Ken said, the real benchmark is, what would a judge say if I was in front of them saying this person's late because they $2 short a couple months? So I think that's it. Next question. I apologize if this is too specific. An association CC&Rs state that a business cannot be run out of a home in the community. Have there been laws passed or changes to the RCWs in Washington recently, since COVID, that have been passed to allow small businesses to be run from homes regardless of the CC&Rs? This question is way too specific for us to answer in this forum. I would just want to point out that we have had conversations over the past, 6 months or so about childcare and adult family homes that may have specific rights in communities. So you would certainly want to look to that, but without any more information, and I think this is just too specific for us to answer, we can't tell you whether any particular small business outside of those protected ones would be restricted at this time. Anything to add to that, Ken?
Yeah, the child care one is a post-COVID
Yeah.
piece of legislation that was specifically intended. And so if someone wants to run a daycare out of their single family home in a community, they can do it, regardless of what your CC&Rs have to say.
Yeah, and if you're looking for our conversations on that, if you go to our YouTube page and there's a search function, you can just search childcare, and I think you'll come up with our previous conversations about that.
Next question. What is the protocol for getting a second opinion on a legal issue? Do you ask an attorney in the same firm, or do you ask an attorney from a different firm? Would attorneys in the same firm have a consistent opinion, or can each member have their own opinion? So this raised a couple of interesting points for me. One is I would offer that I'd expect that the attorneys in one law firm would have a consistent answer. And that's in part because we do talk amongst ourselves, and there are some things where we sort of take a firm policy. I know we do that for a lot of the collections related things. And in our office, every attorney looks at a foreclosure lawsuit before that foreclosure is done, because we're trying to make sure that there's not more risk to our client or our office. But part of the question is, or the answer would be, if you don't like the answer that you got from one attorney, that would be a reason to go get one from another attorney. But it also may depend on what you're trying to accomplish or what you're really asking. There are certainly times where someone asks me, what does the declaration say? And I will say, here's what I believe the declaration says. And if they come back and they say, well, we really want a different answer, can you provide a good legal argument for the answer that we want? And the answer might be, yes, we can do that. And so you've seen a lot of litigation over the rental caps over the last 20 years, and now over short-term rentals. And these are occurring not because, attorneys are necessarily right and wrong. They are occurring because the client is coming to the attorney and saying, I want a different result than the one which you think is most likely. Can you provide a legal argument that we could reach that result? And, the Wilkerson v. Chihuahua, which was the first one on short-term rentals, that client cared so much about the particular issue, they were willing to pay attorneys to argue the point of view that they wanted all the way up to the state Supreme Court. They ultimately lost. But it doesn't mean that the arguments weren't reasonable. When the Fillmore case, Fillmore v. Centerpoint, went up to the state Supreme Court over the issue of a rental cap, the state Supreme Court declined to actually say what the law does. Okay, they held that the association lost based on the governing documents for the community, instead of on the statute, which said you needed a 90% approval for restriction on use. And so there is this, open legal question. So if your question is about, something where you get a legal opinion and you don't like the result, one of the first things you might do, instead of just going to another lawyer and saying, what is your opinion, is you might talk to the lawyer and say, how strongly do you think that this is the result? Is there a legal argument? Could we argue that, short-term rentals are really commercial use? Or could we argue that these are businesses which are not allowed? Or, can you make some argument that it's a nuisance to the community? Is there some other kind of legal argument that you could advance for us as a client to achieve a result which we're looking for? Because that's different than just going to another attorney and asking for a different opinion. So any thoughts on that, Lisa?
No, I think that covers it. Next question. If an association has not put the minimum required amount of money into their reserve fund over the years and fails at their 5-year cash rebuilt plan, what are the possible consequences of that? I will start by saying there's no statutory minimum required for contributions to a reserve fund. The statute just requires that you have an account. But what WUCIOA requires that you have an account. It doesn't have to have cash in it. Doesn't have to have anything in it, just have to have the account. But the short answer to the question here would be this association may need a special assessment. If they don't have funds required in their reserve account to perform whatever repair or replacement needs to occur, they may be facing a special assessment for that association. If they have not planned ahead, they do run the risk of needing special assessments, loans, things like that to afford the repairs that need to happen in their community. I put down also the possibly this could have other bad results, I guess. Potential purchasers may not be interested in looking at this community if if there are underfunded reserves. But that's why you have that information in your annual budget disclosures, why you perform a reserve study to show your community and others what the potential risks are. But the short answer to this question is you may end up needing a special assessment if you don't have the funds available according to your reserve study plan. Anything to add to that, Ken?
No, it's pretty short and simple. Number 10, we received a couple of questions about the 2021 fire code. And I'm just going to offer, we have not reviewed the fire code other than as specific to barbecues. And so we can't offer opinions about the fire code. If you've got questions about that, you can contact an attorney or the building code enforcement people with your local city. Often the fire department will have some help with that too. We know that at least a couple clients did have the fire department come out and help them to interpret the code as it applied to their building, specifically regarding barbecues and open flame devices on balconies. So.
Okay. Next question is a two-parter. The first part is, could you explain RCW 64.38.075? And the second part is, if a managing agent is caught doing computer fraud, should the association use their association insurance? So for the first part, that section is in the HOA Act is about reserve account withdrawals. And basically this says that if the board uses reserve funds for any purpose other than what they're intended for, they have to notify all the owners and plan to repay those funds unless there's some sort of a hardship for the association not to do that. So there's the statute sort of lays out what and how to notify owners about any sort of off book, I guess you'd call it, withdrawals from the reserve account. The question about fraud, I'm hoping that this question and everyone has crime and fidelity insurance as part of their association insurance policy. That claim for fraud by a manager or by anyone, I guess, who had access to the accounts who was an insured, would be, you present that claim to your insurance policy for coverage of that claim. If the money is lost, for any reason, but if the specific question was whether there's computer fraud going on, I don't know exactly what the person's intent of that question is, but yes, you would present that claim to your insurance company. Your insurance company may, unrelated or related to this, have a claim against that person's insurance, subrogation claim it's called, but for your purposes, for the association's purposes, you present that claim to your insurance policy and your insurance company reviews it under the crime and fidelity portion of your policy. Anything I missed there, Ken?
No, I think that's correct. There's certainly the potential that the management company would also have some insurance,
Right,
which might cover the loss. Your goal, though, is to get the money back. And if you have insurance, then get the money from your insurance and let them worry about going after the management company's policy instead of you. Next question. If an old Act HOA doesn't require a supermajority vote for declaration amendments, and the declaration has always allowed tenants without any restrictions, can the declaration be amended to require that tenants be full-time residents without a supermajority vote? Okay, so this question is too specific because it would depend on both the type of restriction and the original language of the CC&Rs. So, we under the Wilkerson v. Chihuahua case about short-term rentals, any kind of new restriction on tenants would require 100% approval, not just a majority. If it was a restriction for an old act condo, it might require a minimum of 60%. For a new act condo, it might require 90%. So it really depends on the document, the kind of restriction, whether it's modifying an existing restriction or creating a new restriction. But I will also provide one unrelated note, is that when UCIOA takes effect, the minimum percentage required for an amendment is going to increase from 60% to 67%. So if you are an old act condo, or if you are an HOA that doesn't require 67% now for an amendment, you might want to look at having amendments done before UCIOA becomes binding on your community, because the threshold is going to go up for you on those, because the minimum under the new statute is 67% for an amendment to the CC&Rs or condo declaration.
And I think that pretty much answers my next question, which is that regarding amendments in a prior Zoom meeting, Valerie said, usually what the statutes do is set the minimum percentage that's required while allowing the declaration to set a higher percentage. And so this question asks, if the declaration specifies a simple majority is 67%, the required minimum. And our answer is, as Ken said, under WUCIOA, we think the percent to amend will go to a minimum of 67% for every type of community. And that is found in 64.90.285. Anything else on that one?
No, you're good.
Okay.
Besides spelling and punctuation corrections, are there editorial changes that can be made to the declaration without a vote of the membership, such as minor changes to fix or clarify bad grammar? Okay. So I'm going to again say too specific to know for your case. You don't have the authority under the Condo Act or the HOA Act to mend for corrections to grammar and punctuation. Under UCIOA, the board can vote to make those corrections if 2/3 of the board members agree. And also under UCIOA, you can amend for Scrivener's errors, and you can correct objectively verifiable information. And you can remove conflicts, and as for example, if when UCIOA comes into place and you have a conflicting provision in your declaration, the board can remove it. So after UCIOA takes effect, the board could revise the amendment provision in your declaration to go from 60% to 67% because it is a conflict between your document and the statute. Okay. You also are allowed to remove discriminatory language from declarations with just a board vote. But other than that, swapping parking spaces or revising limited common elements can be done without approval of the ownership for most new act condos and UCIOA communities. But otherwise, you still need to have the membership vote on any substantive change. Anything you want to add, Lisa?
No, I think I would just say that, part of the question was fix or clarify bad grammar. And I think that's sort of what makes the legal profession go round is, your view of something as bad grammar might be a comma in a different place might actually mean something different. So you might be actually changing something dramatic about your declaration, but just what you're seeing as clarifying bad grammar. Anyway. Next question. If a board signs a loan that has not been subject to a required notice of meeting and vote of the owners, subject to whatever quorum or majority requirements apply, is the institution providing the loan required to cancel the loan when notified they didn't have the authority? Or would the institution typically have an interest in canceling the loan to protect itself? Or would the institution require some statement from the association that it had achieved the necessary votes? This is a very specific question that is a little bit hard for us to answer, but generally speaking, the board is not required to have or to ask the owners to vote on citing a loan document. That is what the board is for. They're using their business judgment to act on behalf of the association. Of course, if there's a special assessment tied to a loan, that would be something that the members would need to vote on ratifying the special assessment, according to all those budget provisions we've talked about ad nauseum under WUCIOA, the notice provisions. But questions about cancellation and things, whatever what the institution would do are way too specific for our purposes. But generally speaking, a board gets to make the decisions to enter into contracts. The association as a whole, the community is not required to vote on things again, unless it's something like a special assessment or a budget consideration. Anything to add to that, Ken?
Two comments. One would be that under UCIOA, it is necessary to ratify a loan with a meeting the same as a special assessment. Usually you have to do a special assessment to repay the loan anyway, so you're doing them together. But UCIOA does have a specific provision for association loans. And then the other part of the question is that a bank can rely on representations made by the association unless it knows they're wrong. So if a board comes to a bank or any third party and enters into a contract, the general rule is that the bank or the third party vendor is not required to do the association's work to prove that they had the authority to enter into that agreement, and the agreement will still be binding. It certainly has the potential that if the board acted improperly, that they would be in default under the terms of the loan. And that's a whole other can of worms we won't discuss today.
I think the next question is mine also, just to keep our numbering easy to understand. Can you clarify how to correctly follow the bill regarding release and publication of homeowner contact information should it become law? Language is a little confusing in its intent. Does anyone considered a resident, does anyone who's considered a resident must have their email address redacted? First thing I need to say is this is not a should become law. This is the law. All communities statutes, including WUCIOA, were amended to reflect the records disclosure. We've had lots of conversations about this over the past, I think this was in July of 2023. So we've had lots of conversations and Q&As. So for more specifics, certainly, as I said, go to the YouTube channel and Google that. But generally speaking, phone numbers and emails of owners should not be released to anyone else unless the owners has specifically allowed or agreed to have those be released. Owners are allowed to have a list of all the other owners, which would include their mailing address and their name, one time per year for free. So if an owner requests a list of all the membership, they can get a list of the members, not their email addresses unless the owner has consented, but they can have their name and their mailing address. But I do want to clarify, this is the law now. And we've I think that's about it. Any unit specific information. So if an owner asks for information about someone else's unit, most of that needs to be redacted. But again, go and look at our prior conversations about this topic. The moral of this question is don't release email addresses to anyone unless you have consent of that person. Anything to add to that, Ken?
Did you talk about the providing of the name of the owners and
yes,
their mailing address, not email, but postage mailing address?
Yep, you get one freebie.
Yeah. Okay.
Did.
Then I apologize. I'm dog sitting today, and the dog decided it needed to bark at something.
We didn't hear it, so.
Okay, so
number 18.
If an association wants to switch from the Condominium Act to UCIOA, what is the process, time frame, estimated cost, and do owners have to vote to approve? So there is a specific process in RCW 6490-095, which is part of UCIOA, for how an existing community can adopt UCIOA. It's a fairly straightforward process. You have to, basically the board has to decide they want to do it. You have to mail a notice of a proposed amendment to do that to all your owners. You have to wait at least 30 days and hold a meeting for the owners to discuss it. Then after the meeting, you send out ballots to all the owners to vote with a due date. And on that due date, if at least 30% of the total voting power has voted and 67% of the votes cast approve, then you've adopted WUCIOA. So the legislature back in 2018 was really excited by their new statute. They wanted to make it really easy for communities to adopt it. So they made this essentially exception to the quorum rule. And so if you can get 30% of your community vote, then you just need 2/3 or 67% of them to approve. In terms of the time, we've seen it done in as little as, say, 6 weeks. We've seen it take months because boards couldn't get their act together to call the meeting or to schedule the ballots to be due. We do a flat fee for a single purpose amendment like this of $1,300 in our office. The county records for another fee of around $325. So if you want to adopt WUCIOA today instead of waiting until January of 2028, it's certainly something you've had the ability to do for the last 5.5 years, and any of the law firms in our practice area can help you do it. Anything to add, Lisa?
Nope. Next question. With the rising insurance costs for associations, can the board require owners to cover the increased deductible for the association with their individual owner's policy? Is the association obligated to address this insurance gap as an amendment to their CC&Rs, or can this be done in the rules and regulations? Short and sweet answer to this is that it has to be done in an amendment to the declaration. There's no other way to change this portion of your declaration. It has to be an amendment. And as Ken pointed out to me, this is one of the most popular amendments that our office does, because your insurance agent will often recommend it to, or will often recommend to a board to increase the deductible. And so we come up into this situation where a board is looking at a much larger deductible than what they had previously had before to save costs, annual insurance costs. So again, you have to amend your declaration to make this change. Anything to add to that, Ken?
No, I think that's good. Next question. A condo community is looking to add an anti-harassment policy for all residents. Would this be best added to the rules and regulations? Would an attorney need to be consulted to ensure legality? So we usually recommend that it become part of the bylaws. And we do include it in our sort of model bylaws that we use now. But it can certainly be done with a rule as well, or just a standalone policy. There are, I'd say we would recommend attorneys to assist, but we're biased in that regard. And there's probably a wealth of information on the internet from other communities or organizations which have adopted anti-harassment policies, and you could certainly look at those. They are something which are difficult to enforce. And there was a decision by HUD, now I guess 4 or 5 years ago, saying that if an association had any power to sort of fight discrimination within their community that they know about, they should exercise that power. And so at that time, many of the law firms across the country started recommending that clients adopt anti-harassment policies. You wouldn't have to enforce them for one owner on behalf of another specifically, but at least it would be kind of a public policy statement that you are, opposed to this kind of behavior, and it would provide some grounds in your governing documents that would make the behavior a violation if it was extreme. Anything to add to that, Lisa?
Nope, I think that's it. Next question. If a 55+ HOPA community amends their declaration so that any future sales and rentals require 100% of the homes to have at least one 55+ occupant, can the amendment also allow younger resident survivors and non-resident beneficiaries to live in the community in up to 20% of the homes? And our response is, if your amendment is written that way, then yes, that is what you can require. Make sure that if however you amend your documents is how you want want the result to be. So as long as you comply with HOPA, with the percentage requirements of HOPA, and your amendment sets out as requested in the question, that you should be able to enforce that. Anything to add to that, Ken?
Nope, I think you're good. Next question. Do some associations governing documents or rules require meeting minutes to follow a particular format, such as using a template? So certainly a set of association, or, association could adopt a template or create that. I have not seen it in the governing documents, which I've reviewed, and I've reviewed quite a few. There are a lot of associations that will have an agenda for the annual meeting, for example, written into their bylaws. And we would typically see the meeting minutes follow the agenda of the meeting, because as topics are discussed, they would have any motions made or adopted reflected in the meeting minutes. There's no template for an agenda in the statute. So if there's not an agenda, the secretary can certainly use one that complies with the requirements of the association. And then as a reminder, Lisa reminded me that the minutes that you get are not a transcript or, word by word recitation of what people had to say. The minutes need to reflect motions made and actions taken. And I like them to also reflect a small recital on information used by the board if they are using it to make a decision. So, for example, if the board is approving a shed in a backyard, that it would say that they had, the board had considered the design submitted by the owner on comments from the neighbors and the architectural standards of the community, and had voted to approve or not approve the shed. So anything to add to that, Lisa?
No, I think you mentioned this, but typically the best minutes I've seen are the agenda with just the results, and as you said, potentially a reference in it. So the secretary using the actual agenda as the format for the minutes of the meeting keeps it short and sweet and makes sure that all relevant motions and results are reflected.
There are actually, that reminded me of one thing. There are a couple of specific actions related to collections that we must have reflected in the meeting minutes for us to proceed. And so maybe Lisa can comment on that too.
Yeah, so for example, the foreclosure statutes require that the board meeting minutes reflect that the board approved the association proceeding with the foreclosure lawsuit. So this may be one of those situations where the board makes a motion to retreat to executive session to discuss specific persons' delinquency, but then they would then come back into the regular meeting. Someone would make a motion to proceed with foreclosure on unit X or account number Y, whatever it is. And then the results of that motion would be reflected in the minutes. And then I would ask you for a copy of those meeting minutes that show that the board did vote on and it was approved. So that's one particular example.
Yeah, my guess is that the legislature believed a lot of management companies were following policies that were sending people into collections and to foreclosures without the boards being aware that it was happening. And so the legislature made this extra requirement that the board of directors has to approve every individual foreclosure. They cannot just adopt a policy and then have their employees or management company follow the policy.
That's right. And as we've talked about before, that particular motion, and in fact, any other, could be done by email as long as it's all board members acting unanimously, all board members voting, and then the results of that being reflected on the following month's meeting minutes. So again, that they are in the minutes for me, if that ever comes up. Ken, do we want to go on to the next question, the extra questions we have, or do we want to see if there's any chat clarification requests?
I would just keep proceeding here.
Okay. So the next question is, does the term governing documents include, for example, the rules, the maintenance matrix? What does that include? Generally speaking, the term governing documents does include the rules, it includes the bylaws, it includes the declaration. Something like the maintenance matrix would require a specific adoption, so the board would need to adopt that maintenance matrix again at a meeting. But as of today, that is the rule. That WUCIOA specifically lays out definition of governing documents, which are the organizational documents, the map, declaration, rules, etc. The maintenance matrix itself is typically a legal opinion about the declaration, so it is not necessarily, it is not a specific item set out as an example of a governing document. It is more of a legal opinion that the board may follow as an interpretation of the declaration. It's not something that is in the board's discretion. Anything I missed there, Ken?
No, I think that covers it.
Okay.
As a follow-up to that, if a board changes the rules or a maintenance matrix, is there a requirement to publish a notice and or send those documents to owners? So I would say as a general rule, yes, any revision to rules and regulations has to be provided to the owners in order to be enforceable against them. Under WUCIOA, the owners must be given an opportunity to comment about rules before they have been adopted by the board. So you can end up in effect sending it to them, all the owners, twice. Once in a sort of draft or proposal form, and then second as a, here are the rules as they were actually adopted by the board. And we like to have them actually show an effective date on them. In terms of, how you provide notice, if you want to make sure that you have full enforceability, you would provide notice as provided in the statute, which would mean you mail it to them unless they've agreed to accept electronic notice. Lisa's comment here is that she thinks it's best to have a password protected website for your community members where people can go and review all of the rules, the most recent financial documents, the governing documents for the community, any other policies which the association is using with regards to how the community functions.
And that doesn't avoid the obligation to send out rules, et cetera. If that's just for reference for owners, if they are curious, it also cuts down on time asking you for production of documents. I would also just point out that if you're sending rules out with an effective date, make sure that effective date is after the date you send out to the owners, so that they're not, they need to have a reasonable time period between the time you send it out and the time in which that goes into effect. Okay. When should the board formally approve the minutes of the budget ratification meeting? Should this be at the subsequent budget session or a subsequent board meeting? This is a good question. We think that the next board meeting would be acceptable. And then the minutes of that would then be subject to revision by the next full association meeting, be on their agenda to ratify those. But I think it makes sense to have the board at the next meeting ratify the minutes of the budget meetings, that they're available to the ownership. And note that the HOA Act under 6438.035 says that you have to make minutes available to owners no more than 60 days after the meeting. So make sure that those are sent out to your ownership if you're subject to the HOA Act no more than 60 days after the meeting. I think that's a reasonable time frame in general. You would basically send them out to the ownership after the meeting for review, and then at the next board meeting, the board would then approve make a motion to approve those minutes or amend them as they decide at that meeting. Anything to add to that, Ken?
Well, I think this is a good example where the legislative intent is really unclear.
Yeah.
We don't know how they can require that you send out meeting minutes for an annual meeting within 60 days when you might know that the process for approving those minutes can't occur for another year.
Right.
And so our advice would be that the board goes ahead and puts together the meeting minutes and approves them at a subsequent board meeting, subject to the right of the owners to have a motion at the next annual meeting to amend them, because technically the board is not who conducted the business at the annual meeting. That was the full membership.
And this would be for both annual meeting minutes and budget meeting minutes if they're not the same meeting, right?
Yes. Next question. Is it appropriate to transfer the deductible to an individual unit owner if the damage is caused by a common element for which the association bears responsibility to maintain? So this, the short answer, of course, is it depends on the condominium document that you're working with, and it always depends on that. But the question really comes to, I'll say, a question of fairness. I have a lot of clients that don't think it's fair that a unit owner has to pick up the deductible under the association's policy when it's something like the roof that leaked or a tree fell on the building where the owner did nothing wrong. And the answer is that you're trying to get the benefit of increased insurance coverage, and meaning more money from insurance companies in aggregate, and a higher deductible to reduce the number of claims so that your association policy doesn't get canceled or become unreasonably expensive. And so our answer is yes, it's appropriate to transfer the deductible to the owner of the property which is damaged. So if a tree falls on the building, the association would get to restore the common element structure, the roof, the attic, etc., and the unit owner would be responsible for the deductible as it applies to the unit itself. So carpet, paint, and cabinets. And this is specifically provided for in WUCIOA. It is how attorneys in Washington State have been writing amendments to deal with insurance now for more than 30 years. And so is it appropriate? Yes. Is it fair? It's fair because you're trying to allocate the risk to an individual who can buy insurance for it. So you can disagree with that and have the association pick up all those deductibles, but you will not get the benefit of reducing the cost to the association if you do that. So anything to add, Lisa?
Nope. Next question. Is the management company required to maintain records of all violations, delinquencies, or correspondence sent to the owners? You need to start by looking at the record statute we talked about before that were revised in 2023. The answer under that statute is probably yes, since the association itself would be required to maintain those records. It would make sense that because the manager is contracted and an agent of the association, that they would then be obligated to keep them on behalf of the association. You should look to your contract. It may specify who is required to keep those documents. I don't know the specifics of this particular contract or what we're talking about, but that's something you could look at. But generally speaking, as an agent of the association that is required to keep those records, yes, the manager would be required to do so. If you want, you can look at all the statutes are the same. Again, we talked about the records statutes. You can Google 6490, 6434, et cetera, and records. If you want to look at the language, it's in 6490, 495. In WUCIOA, it's laid out pretty specifically what records are required to be maintained. Anything to add to that, Ken?
Well, I would add that the new statute adopted or that took effect in July is specific in requiring management companies to transfer records to a new managing agent or to the association when requested by the association. And that would include all of the delinquency notices and correspondences sent to owners. Those are all records of the association. We have seen inconsistent transfer of records from one management company to another, and often a lot of information gets lost. I think the legislature intended to keep all that information moving to the next location so that the association could comply with its obligation to maintain violations records and ACC requests for 7 years, etc. So I guess my short answer would have been, yes, you have to keep the records, because I think that's what most management contracts would require in their association obligations.
And I would say from a practical standpoint, as a collections attorney, we run into this all the time. That when there are records that are missing for some period of months between management companies. So really want you to keep this stuff.
Yeah, it's really hard for us to collect on a transfer balance of a single dollar amount with no explanation from management company 1 to management company 2, because we need to be able to know all of the detail about that debt in order to collect it.
Yeah, I think under the FDCPA, I can't collect that debt unless I can verify and validate.
Right. So we actually have a little time for another question. Chelsea, if you got one you would suggest.
We did have a follow-up to the last question asking if we could provide a link to the record statute again.
Yeah, I mean, basically it's, again, if just Google your statute and then the word records, but I think it was
under the Condo Act, it's 6434-372. And the HOA Act may be 6438-035. I don't remember the old act.
and under Iowa, it's 649495. That
But
should get
again,
us
if
started.
you go to Google and type in your statute number and the word records, the legislative website is almost certainly going to come up and give you the section.
And since I've given you those ones, you can actually just Google that RCW 6438-035 and it'll come right up.
All right. We also have, if a WUCIOA community does not have a reserve account due to the board refusing to set it up, what are the possible repercussions to the board/association?
Well, I'll take a stab at it. You would have to be able to demonstrate that you had damages as a result of the failure to produce that. And I don't know that you could demonstrate damages. We certainly have some clients who intentionally choose not to fund reserves, and instead they will rely on special assessments whenever they need to replace something. And the legislature allows for that kind of business judgment by a community. And my advice to a WUCIOA community would be just go open a bank account. You don't have to put money in it, or put $100 in it and don't worry about it, because the statute does require it. And we do see, people sue over procedural failures, which are easy to prove. And so if someone were to sue the association because they didn't have a reserve account, my advice would be go open a bank account so that the lawsuit becomes moot. There's no reason for it, okay? Because you don't have to fund it. But, repercussions, certainly there are a lot of people who get really bound up in the idea that there's a statutory requirement or a requirement in the declaration or the bylaws or the rules that something be done exactly a certain way, that a response be provided within X number of days, or meeting minutes are posted within X number of days, and that the failure to do that is a breach of contract. And it's not enough in the legal world to have a failure to do something, even if that obligation is clear, if you don't also have some kind of injury or demonstrable damages. And sometimes there's a remedy specifically provided for in the statute as well. So there's a remedy written into the statutes on a failure of an association to have a reserve study. And the remedy isn't monetary. It's just that you do a reserve study. Did you have anything to add to that, Lisa?
Nope, I don't think so.
One thing I will offer for people who really care about this stuff, there was a decision out of the appellate courts yesterday, the day before, about political yard signs.
Yeah.
And an owner was told they couldn't put yard signs up more than 60 days in advance of an election. And the court came down really hard on the association and said they were violating the law, and the owners had the right to put up a sign as far in advance of an election as they wanted to. So you can find that on the internet, or if you're really interested, we could probably give you a case site.
Yep.
Otherwise, thank you everyone for attending today.
Thank you, and we'll see you next week.